Hi everyone, Keith Carlson here from Carlson and Jai Kumar. Wanted to provide you with another update on some of the cases we've been watching affecting California employers and healthcare providers. This is for the second week of September decisions that we saw. The first out of the Ninth Circuit is Wolford versus Lopez. This was analyzing a ban in California as well as Hawaii on carrying firearms into certain sensitive locations. The Ninth Circuit applied the United States Supreme Court's ruling in New York Rifle and Pistol Association versus Bruin, a high-profile Second Amendment case from 2022, and essentially stopped the enforcement of California's prohibition with respect to certain designated sensitive places, and that included hospitals and medical facilities. So for the time being, that law is on hold regarding preventing firearms in sensitive places like hospitals and medical facilities. Next, another Ninth Circuit healthcare-related opinion was Blumberger versus Tilley. The court held that when a federal employee is sued for medical malpractice, the United States becomes the defendant and it needs to be removed from state court to federal court. Employees of federally funded health centers can be deemed federal employees, which is a note when it comes to these malpractice matters, and this case was really looking at how the timing of the removal was to work, and that's what was clarified in Blumberger. Another high-profile Ninth Circuit case that you want to be aware of is out of Arizona. The district court had blocked the enforcement of Arizona's Save Women's Sports Act of 2022. This is an issue dealing with transgender athletes. The transgender legal issues are percolating up and I think are going to have a pretty noticeable effect on employers and healthcare providers throughout California. That's why we're taking a look at this one. The challenge came under the 14th Amendment, Equal Protection Clause, and Title IX theories as applied to these athletes, which essentially stopped them from participating in girls' sports in Arizona. The trial court issued a preliminary injunction. The Ninth Circuit affirmed that injunction, so the act is on hold for right now. The panel essentially found that the trial court did not err by finding that before puberty there's no significant differences in athletic performance between boys and girls. They thought there was no reason to treat small differences as significant. They thought they were insignificant, and they found that the transgender girls who receive puberty blocking medication do not have an athletic advantage over other girls in sports. So this is how the Ninth Circuit court in this area is approaching some of these transgender issues. We'll see how that down the road affects more issues as they come up in employment and healthcare settings. But for now, Doe versus Horne puts some difficulty in those seeking to prohibit transgender athletes, at least, from participating in sports opposite of their biological sex, but more their determined sex. The panel that ruled on this for the Ninth Circuit said that the prohibition by Arizona was discriminatory on its face based on transgender status, and that used a designation of a standard of review that is going to make it essentially very difficult for the state of Arizona to continue forward with that prohibition. Another Ninth Circuit opinion I wanted to alert you to is Silloway versus the city of San Francisco. This overturned a summary judgment in favor of the employer, with the appellate court finding that there was in fact factual issues that needed to be determined by the lower court. The appellate court was ruling on an overtime case here, and the question is, was the city of San Francisco, who was the employer, actually using the salary that it was publishing, what was the case for certain nursing positions? The issue was, were these nurses exempt given their professional capacity, professional status? Were they exempt professionals? And the city was arguing they were paid a salary, and the question is, was that actually what was going on? Because there was a factual issue, the appellate court wanted the trier of fact to determine it. Next up is a healthcare case, but from state court, McCurry versus Singh. A doctor won summary judgment on a malpractice claim The court found that the doctor did not owe the plaintiff a legal duty of care because there had been no establishment of a physician-patient relationship when he had denied care in the first place. There's some of the cases we've been looking at for the prior weeks, and we ask you to reach out if you have any questions or need more detail. Thank you.